have him testify or provide his opinion to the court at the sentencing hearing. And yes, we have listed and we have provided information to Dr. Bloomfield in light of the state's intention to move forward with Pritchard, and unbeknownst to us what the court's ruling would be on this motion. So that's why Bloomfield is in the wings, so to speak, Your Honor. But it's our motion and opinion that Pritchard's pending testimony or potential testimony in this particular instance is improper, and we're asking the court not to allow it. Thank you.
Thank you, guys. Anything else from the state?
No.
All right. All right, in reverse order, as to the motion in limine to prohibit the testimony of Dr. Gregory Pritchard, that motion is denied. I am going to permit the state to introduce and to present testimony from Dr. Pritchard. Certainly, we will take up any specific matters during his testimony. If there are things that counsel objects to or specific questions that are asked of him that counsel objects to, we can take those up during that testimony. However, I'm going to permit him to testify during the sentencing hearing. As to the motion in limine to prohibit the testimony of alleged prior bad acts or subsequent bad acts, I'm going to basically table ruling on those until I hear the specific questions. And again, just I'll remind everyone, we are here for a sentencing hearing. This is not a trial. There is not a jury. Typically, motions in limine are to prohibit this types of things from coming before the jury, as you're concerned about tainting the jury or tainting their ability to view the evidence fairly and without prejudice. The court is a little more familiar with the rules, and I can assign the particular weight that any particular testimony gives, or I can disregard it if I find it to be matters that the court should not or could not legally consider. So we'll take those matters up as we proceed during the sentencing hearing. I also wanted to go back and address, I know that there had been some discussion about what I previously ruled on your motion pertaining to the guards and their testifying about the any medications or things of that nature. I am also going to take those matters up. If you want to present that evidence, I may reverse myself on that and allow you to get into some of those things depending on how things go next week, or excuse me, how things go tomorrow. So I wanted to just alert you to that. I know that I previously stated I wouldn't allow it, but I've thought about that a little bit more, and I may allow you to get into some of those statements, depending on what is testified to by some of these other witnesses. Okay? Let's talk about tomorrow. The state, I anticipate, will be presenting first. Is that what we've discussed previously?
And the last motion, Your Honor, or the first motion?
I ruled the same on both of those, that I would be taking those up as we proceed. State, you'll be presenting first tomorrow. What time do you anticipate being ready to call your first witness?
Whenever you like. I thought it was 9, but you can do
Okay.
whenever you like.
Does either side plan on offering any type of an opening or any type of a statement prior to starting, or have you all discussed that?
No, Your Honor. I haven't discussed it with the state.
Okay.
We can.
If you want to, that's fine. Keep it brief, but just let me know. If y'all decide that y'all want to collectively, then that'll be fine. But if not, then we'll just begin with the first witness. You still anticipate completing tomorrow, or?
I think so.
Okay. And does that include victim impact statements as well?
Yeah, if we went over at all, maybe just a continuation of some more victim impact, but I'll just have to see how the morning goes, and I'll have a better idea by lunch
Okay.
of where we're at.
Okay. And then the defense would be prepared to start and then
On Wednesday.
on Wednesday? Okay.
And can we approach, but have it, the Madam Court Reporter could still
Okay.